Minister, the Honorable Ubao Skwacha, and the honorable members that are on the platform, our staff, as well as legal advisors, and the state law advisor, respected members of the media, Molweni, Dumelang. Molo mphathiswa molo. Molo mntu osedakha molo.
Molo ndisekhatha.
Oh, kuthiwa usedakha abathi khatha.
Ndisekhatha.
Hayi, siyabulisa mphathiswa, sibulela intoba ukwazile uba ube yinxalenye yethu apha kulo mhlangano. Honorable members, let me also acknowledge the respected members of the media that may have joined the session, as well as those
Ulahlekile kumhlekazi.
nakum.
Kuva. Ingathi ulahleke kuthi sonke.
Someone just muted me. Am I audible now?
Yes, Chair.
You are
Yeah. Can you speak to IT Manyamza? It seems someone just muted me. I don't know how that happens, but let's proceed because the members can hear me now. As I welcome you, honorable members, to our portfolio committee meeting on agriculture, land reform and rural development. I want to, as we are continuing with the deliberations on the preservation and development of agricultural land bill, we want to, in making opening remarks, we often take it for granted that we are able to gather here in conditions of relative peace. This is especially true at this juncture in the history of humanity. We gather today where over 11,000 Palestinians have been massacred over the past month, with thousands of them injured and maimed by the relentless act of collective punishment. This is in violation of the precepts of international law. Honorable members, this privilege of relative peace did not come by accident, but rather it comes of an intense struggle against colonialism and the brutal system of apartheid. It is therefore in this awareness and consciousness of where we have come from that informs our deep disdain for apartheid wherever and whenever it appears and raises its ugly head. Before us today, honorable members, we have invited the legal advisors to assist us as we continue with the deliberations on the preservation and development of agricultural land bill. I would like to outline the proceedings so as honorable members can move with us at the same pace and we do not derail from the course of action. In our last meeting, honorable members requested that we engage with the National House of Traditional Leaders of which we took liberty as a committee to invite them to make submissions to the bill. They acknowledged and promised to make a submission, and we awaited that submission as late as yesterday. To this end, honorable members, we have not received any submission as yet from the National House of Traditional Leaders. We therefore, today, the committee will deliberate on the draft A list, which is going to be presented by the parliamentary legal advisor. Honorable members, the A list should include all the amendments that were proposed and agreed to by the committee, including the proposals that were made by stakeholders in written and oral submissions on which the department has made concessions on. If honorable members think that there are any important amendments that were proposed but are not captured in the A list as discussed, they will be most welcome to raise those issues. Having said that, honorable members, the committee should deliberate and reach consensus on each amendment. The legal advisor may advise on how the final clause will read after capturing the amendments. That is how we will proceed today, honorable members. Having dispensed with the A list, we will then make announcements. The legal advisor will then be requested to develop the final A list and the B version for consideration in our next meeting. Allow me to therefore invite our legal advisor to present the A list.
Thank you, Chair. Greetings to the committee members and my colleagues that are in the meeting. Once again, we are indebted to you, Chair, and the members of the committee for the indulgence that you've granted us to be and accommodating us to be able to present the draft A list today. The A list has been finalized between ourselves and our state law advisor, our colleague from the Office of the State Law Advisor, and with your permission, will request Manyamza to flight it for us. Oh, thank you. I can see it on the screen. May I then at this point request that my colleague from the State Law Advisor, Advocate Sean van Breda, read through the A list.
Yes, Chair, good morning. Mr. van Breda here from the Chief State Law Advisor. Good morning, Chair and honorable members.
Good morning.
Chair, I think it would just be easy if I would be able to control the document, if I can be perhaps be given the rights to share my screen, because I'd like to just highlight certain things, if that will be permissible, Chair.
Can I request the Secretariat to enable the legal advisor to be a co-host?
I have granted him permission, Chair. Thank you very much.
Thank you.
Thank you, Chair. Chair, I'll start with amendments to Clause 1. Chair, Clause 1 of the bill provides for the definition of certain words, terms, and expressions used in the bill. And Chair, members of the committee have raised concerns in respect of the definition of landowner, in that the definition is too limited and should include the holders of unregistered rights in land, especially considering the holders of insecure land tenure rights, who are entitled to secure tenure rights in terms of Section 25(6) of the Constitution. Chair, the department has therefore proposed the following amendment to the definition of landowner, and that is on page 6, from line 16, to omit the definition of landowner and to substitute the following definition. Landowner means the person or community who holds a right in land, registered or unregistered, over which such person or community enjoys protection under any law. Chair, should I stop there or should I continue to the next clause?
I would request that you stop there, and also want to correct the proceedings, because this should be led by the Parliament legal advisor, not the state law advisor. The state law advisor is here on capacity to support the Parliament legal advisor. So let us request that we revert back to the proper proceedings and request the Parliament legal advisor to lead the process.
Thank you, Chair. That should not be a problem. I do not know. Perhaps the reason why we thought it would still be okay for my colleague at the state law advisor to lead was because the A list was drafted between ourselves and everything that is contained in it was agreed to between ourselves. But in any event, if the committee feels that it should be done the other way around, we are still okay with that process as well.
Yeah, as I said, that because it is a parliamentary process, it ought to be led by the Parliament legal advisor. So we'll prefer that you proceed in that manner.
Thank you, Chair. We are indebted to you. So, or in respect of clause 1 is as per my colleague has already read out. I do not know whether we should then proceed and finish the A list, or we will deliberate as we go.
We will deliberate as we go. So you may proceed.
Thanks, Chair. Thank you, Chair. I do not know if there are any comments or maybe any proposed amendments to the proposed definition of landowner.
Chair, you might not be able to see, but my hand is up.
Yes, Dr. Masipa.
Thank you, Chair, and good morning, colleagues, and good morning, Mayor Zenani. On this definition, Chair, it states that the landowner means the person or community who holds a right in a land. I think there is obviously, the state owns certain portion of land. That's number one. Have got certain right in a land. And obviously the traditional leaders have got a certain right of land in terms of administration for that matter. I just want to get a feel, is that covered in this explanation? I'm not a legal person, but I'm just asking if that has included those aspects, those two, the state and obviously the traditional leaders who has got some administrative responsibility of particular tribal land. Thanks, Chairperson.
Go ahead, Mama Zenani.
Thanks, Chair. Our proposed definition was informed by the complaint which we accepted that in its previous form, the definition only included registered rights, and we thought that the proposed definition will be all-encompassing. So we did not think of specifying which rights would be protected, which ones would be excluded, but we thought that in its current form, it's all-encompassing.
Chair, if I may, it's Mr. Van Breda speaking. If I may
Yes,
just
go
add
ahead.
something. Thank you, Chair. Yes, Chair, we believe that it is indeed all-encompassing. In respect of Section 25(6) of the Constitution, they refer to not to traditional leaders in that respect, and that's in accordance with the relevant constitutional court judgments as well. Is that we have to refer to persons or communities in ownership, and not necessarily to traditional leaders. There is provision in the text of the bill which does provide for traditional leaders to actually make inputs in respect of the declaration of agricultural land and certain and certain listed activities, Chair. So that they would be included under the public and interested parties, so they would fall under that. So the definition of landowner is indeed all-encompassing, Chair. Thank you.
Thank you. Continue.
Apologies, Chair, my hand is up.
Yes, Dr. Masipa.
Chair, I have got a title deed of a land somewhere in Moleji, that particular area, that obviously is under, if I have to read here, is under S. Moloto, Minister of Native Affairs for the Union of 425 of South Africa, in trust of Moloto Tribe, Native Act. So I'm just saying, Chair, there are obviously these instances that exist in law, that there are certain lands that are obviously registered in the deeds with native tribes as such. So I think the point I'm making is that I'm just feeling that, Chair, we might not have defined the landowner, accordingly. And obviously there are areas of, where department owns the land and the municipality owns certain pieces of land like commonages as such, So I just feel that this definition is not encompassing, if I got the word right, it's not inclusive of those aspects. Thanks, Chair. That's my submission.
Thank you,
May
Dr.
I come in,
Masipa.
Chair?
Okay, please go ahead.
And myself
May I
also,
come in,
Chair.
Chair?
After her.
Yes, go ahead.
Nkosi, thank you, Chair. I'm also worried in cases where the person owns the land under a legal entity. I don't think that has been included here as well. Thank you.
Thanks, the Honorable Baukapa.
Thank you, Chair. I was also wondering if, in this case, the term person means a human being, or it can also mean an entity or a group of persons. If that be the case, I would have been covered. I would feel that I was suspecting that if that's the case, it covers anyone, whether it's a group of persons who can be owning land, so as to make sure that there is no misinterpretation of this. So to me, that's a clarification by our colleague here, legal advisors, on the person, whether it's limited to one human being or it legally explains even an entity can be referred to as a person. I thank you, Chair.
Thank you, Mama Zenani.
Thanks, Chair. In our view, once again, we thought it is all-encompassing. You will note that in on the second sentence of the definition, it says registered or unregistered. So I do not know if that would not cover the entities as well, or human beings as well as entities or companies that may own the land.
Thank you, Mamo Zenani, State Law Advisor.
Thank you, Chair. Yes, indeed, the reference to person refers to both natural and juristic persons. So that would include entities, businesses, groups of persons. So that's in terms of the Interpretation Act, Chair, where the term person is defined. So that indeed is all-encompassing. Thank you, Chair.
Thank you, honorable members. The definition is all-encompassing, so we will move on.
Thanks, Chair. Our next proposed amendment is in clause 11. Clause 11, the complaint was that it seems to be covering only food production and seems to leave out any other agricultural production. So the proposed amendment is that it should then include other agricultural production. So we said it would be the preservation of the area primarily for food and other agricultural production. So we have inserted in clause 11 and other agricultural production. Thanks, Chair.
There doesn't seem to be any hands. We may proceed.
Thank you, Chair. The next clause would be clause 17. The proposed amendment was that we should also consider including other forms of media other than the Government Gazette. So we have accepted the proposal and we have included in our amendment the and other media. Thanks, Chair.
If there are no interjections or show of hands, honorable members, we'll move on.
Chair, sorry, my hand is not up, but apologies, Chair. Can I come in?
Yes.
Chair, obviously you did indicate at the start that we should also consider the proposal or the comments that were made during the public hearing and obviously during the oral submission in Parliament. So we've got all the proposals on the annexure that we were provided, obviously, by the content advisors. So I was just thinking, Chair, because the legal advisor from Parliament did not include most of them, because now we have done with clause 17, which we are happy that other media has been obviously inserted. But there is obviously, we move into clause 20, but we have got clause 15 that the submissions were made. I was just thinking, shouldn't we also, touch all those clauses that are in between as we go along, or make inputs towards those clauses that have been left out? Because, as you said, that it must include clauses that obviously the department has considered to, but made a concession, but clauses that we be proposing during this deliberation. I'm just asking
Zenani, please mute your microphone.
I'm
Yes,
just
Tate
wondering
Masipa.
if we could adopt that process, and if you allow us to do it that way. I do not know, but I think members can also advise whether the content advisor should assist in terms of highlighting these clauses that we feel have been left out in the A list that should have been in the A list in the first place. Thanks, Chair.
Thank you, Honorable Tate Masipa. Any further input, honorable members?
Yes, Chair, and Tate Masipa's suggestion is supported by myself.
Thank you, Mahmoud Papama. Honorable members, the parliamentary legal advisor as well as state law advisor have taken into consideration what was raised, and they've effected the necessary changes as best as they've been able to identify wherever necessary in terms of what members feel ought to have been looked into. We can revert back to that. So in terms of clause 15 that Honorable Masipa is raising, what exactly do you want amended on clause 15, Honorable Tate Masipa?
Sorry, Chair. The suggestion that was made by ACPACE in terms of this clause 15 was that there should be a, let me just go back to my notes. There should be the words where required should be added at the end of the sentence. And my recollection is noted here by the content advisor that comment was noted and accepted as it was proposed by the ACPACE at the time. But decided to not include it.
Chair, may I just assist just on this part?
Yes.
The proposal that was made in clause 15 has been considered and has been deferred to the amendment in clause number 20, which we're going to read out now. Clause number 20 deals with the consideration of application by competent authority, which is the same thing that clause 15 2 talks about.
Thank you. You may proceed.
So we noted the proposal that came in respect of clause number 15.2, where it was proposed that we put in timelines with regard to the consideration of the application for ecosystem authorization. But because clause 20 deals with the process of and the consideration of the applications referred to in clause 15, we thought that we should rather incorporate the timelines. We accepted that there must be timelines that are set, but also guided by the kind of application that is made. And then we thought that we should include those under clause 20, which deals with the consideration process. So we have inserted a new clause 20 sub 2A, which reads as follows. The competent authority must consider an application for an agroecosystem authorization and provide the applicant with a decision in respect of such application within 30 days of receipt of the application or within a reasonable time as may be prescribed for certain specified agroecosystem authorizations, and must, in the case of a refusal, provide written reasons for such refusal. So that is the proposed amendment, which addresses the complaint raised in respect of clause 15, subclause 2. Thanks, Chair.
Continue, Mom Zenan.
Thanks, Chair. And then then clause B becomes what was clause 2 in the initial bill. So it would read as follows: the competent authority must keep and maintain a written record of all applications submitted for agro-ecosystem authorizations and the reasons for his or her decisions in respect of such applications. Then paragraph 2, then with the consequential amendment.
Chair.
Honorable Masipa.
I just wonder, sorry, Chair, I just wonder if Ms. Zenani can just, maybe as you go through, obviously the submissions were made, instead of us, chipping and stopping, just to say, with regards to this amendment, there has been it has been added, because I've got clause 15.5, where it is recommended that the provision be amended to read as follows: compliance with procedures laid down by the minister in terms of this act does not absolve a person from complying with any other statutory requirement to obtain an authorization from the organ of state. I listened to, as Ms. Zenani was reading, I couldn't pick up that it was added onto clause 20, and as to what happened to this particular input. Chair, that's my submission there.
Ms. Zenan.
Chair, may we come back to the point? May we be allowed to perhaps finish with what we have prepared for now, and then we'll come back to the point that has been raised by Honorable Mr. Masipa.
All right.
Can I come in there, Chair?
Please go ahead, Honorable Kapa.
Yeah, thank you, Chair. Ms. Zenani comes exactly when I thought that when I was reading this document, I remember getting through what Honorable Masipa is saying. And therefore, that made me confident that we are still coming to this part, because I remember reading it in this document. I thank you, Chair.
Ms. Zenan, you may proceed.
Thanks, Chair. We are on clause 21. The amendment that has been effected would be in respect of what we have added on clause 21 is subparagraph G. We have also added someone who has been disqualified from serving as a director of a company in terms of section 69 of the Companies Act 2008, which is Act number 71 of 2008. That's the new amendment that we've made, including the consequential amendments.
Continue, Mam Zenan.
Thanks, Chair. And clause number 26, we have made an adjustment in respect of Roman figure 2 of subparagraph G, and it now reads as follows. Subject to the provisions of the Protection of Personal Information Act 2023, information on the landowner and land user, and where such landowner or land user is a natural person, the nationality and gender of such landowner or land user. That is what we have added. Thanks, Chair.
Ms. Zenani, sorry, this clause 26 on page.
Honorable Masipa, I am here as chair, and you shall speak through the chair. We're not having a dialogue.
Sorry, Chair, apologies. Can I just make a point? Thanks.
Yes, Mamu Zenani, go ahead, Honorable Masipa.
Okay, so Chair, apologies. I was just not picking it up, but I do pick up that clause 26 to omit subparagraph 2. There are two subparagraph 2 on this particular clause. The one is subparagraph G, Roman figure 2, and the one is paragraph 26F, Roman figure 2. So I'll assume that this clause relates to the clause 26G's Roman figure 2, where it says information on the landowner or on the land user where applicable concerning nationality and gender. Is it, I think it's addressing that. The changes addresses that. Am I correct, Ms. Zenan? Thanks, Chair.
Thank you, Honorable Masipa. Any other honorable member that may wish to give input? If not, go ahead, Mam Zenani.
I am not sure if I captured Dede Masipa's input correctly. I do not know, with your permission, if he can perhaps repeat.
Okay, so Chair, the notes on the A list now, it reads as thus: on page 17, line 14, to omit subparagraph Roman figure 2. But there's two Roman figure 2 here. There's Roman figure 2, which is 26F Roman figure 2, and there is 26G Roman figure 2. So that's the point I'm making, that maybe, you know, that should reflect that, because as far as I'm concerned, this is a 26G Roman figure 2.
You got that, Mama Zenani?
I got it, Chair. We accept that perhaps we would have imagined that the use of the lines in our A list would make that guidance, because we have said it's on page 17 from line 14. So if you read from line 14, it says that's where sub G Roman figure 2 is. So it would read information on the landowner. So we thought that that would clarify perhaps any form of confusion that may arise. But we take what Honorable Mr. Masipa has said. I think my colleague also from the State Law Advisor wants to add.
May I May I provide some input there, Chair?
Yes, please go ahead, Baufan Breda.
Thank you, Chair. Yes, this is indeed a proposed amendment to paragraph G, subparagraph 2, which is Roman figure 2. The way that the A list is drafted, Chair, is in accordance with the legislative drafting practices. So when we make a particular amendment to a bill, what I do is refer to the particular page as well as the line. So there's all the line numbers on the right side of a page of a bill. So that is just in accordance with legislative drafting practice, but that is indeed an amendment to paragraph G, subparagraph 2. Thank you, Chair.
Thank you, Baufan Breda. Zenani, we can proceed.
Thank you, Chair. The following clause is clause number 31. There, it was just a correction of the drama. We chose to use the word prior instead of the previous notice. We thought perhaps we should use prior notice. It would, and we propose that because it sounds better grammatically. Other than that, we have not made any changes to clause 31.3.
Any input, honorable members? I don't see any hands. Next clause. Zenani, you may proceed.
Thank you, Chair. Our next and final clause would be clause 35. We had indicated in our proposed amendment to clause 20 that some of the timelines will be prescribed in the regulations. So we have considered that on clause 35, and we have in line 8 included. We have inserted including the reasonable time within which a competent authority may consider and respond to applications for certain specified ecosystem authorizations. So that then covers the proposed timelines in clause 20. Thanks, Chair.
Thank you, Zenani. Honorable members, I don't see any hands or any interjections on this clause. We'll move. Yes.
I am here. Sorry, I think. Can I speak?
Yes, go ahead.
Okay, thanks. I think maybe all the comments that I have got will come now when we do this part of the amendments that were excluded in this A list. I was just wondering if now we have the opportunity to talk to these amendments that we have been suggested and have been accepted by the department, as maybe to help us as to why they were excluded in this A list.
You're asking the department to assist us in that regard, why they were excluded.
The parliamentary legal advisor, so not the department, yeah.
Okay. Thank you. Honorable members, any further input? Thank you. I will then request that those that may wish to speak to certain clauses they feel were not attended to can be able to raise that at this juncture. I see the hand of Honorable Masipa is up. Is that a legacy hand, or you still got your hand up, Dr. Masipa?
Chair, sorry. Chair, this is a legacy hand, but I thought they said they will come and really address the changes that were requested that they haven't really made on the A list, or that they have not submitted on the A list. Or should we now go through the changes provided to them, because they are drafted? We have got them from the content advisors. You know, there's just, from my side, there's 3 additional ones that I would also like to sponsor for consideration.
Thank you, Honorable Masipa. I had invited in my opening remarks the legal advisor as well as the state law advisor. And I alluded to the fact that having engaged with them on these clauses will then have the content advisors speak on the same clauses if there's anything that has been left out. Allow me to therefore invite the content advisors to speak on any matters that have been left out, so that they can be able to raise that, and we can have a reflection from the parliamentary legal advisor, as well as the content, as well as the state law advisor. Mamum Kashe, as well as Dr. Manenje, you may come in. Thank you. Can lower your hand, Dr. Masipa.
Good morning, Chair, and thank you. And good morning, members and colleagues. Chair, in terms of the submissions that were made and where the department has made concessions that we feel haven't been reflected in the A list, one of those is in respect of notices. Members will recall some of the organizations that made oral inputs to the committee, including stakeholders in provinces, have raised concerns about department notices and important documentation only being published in the Gazette, because they don't have access in the Gazette to the Gazette. The A list has only made that amendments to include other media, and the stakeholders also spoke to the matter of the relevant language spoken in the area. I don't know if that's covered in other media. So that was in respect where notices are given in the, I'm going through the bill, sorry. It's in respect of the declaration of protected agricultural areas. Clause 11.1, the minister by notice in the Gazette may. The stakeholders have suggested that should also include other media. So I will just mention the clauses where we feel that the amendment that is effected into clause 17 can also be effected into these other clauses. That's 11. Clause 11, that's the declaration of protected agricultural areas. And 12, that's proposals from stakeholders, by the way. The procedure to declare protected agricultural areas, the minister or MEC give notice in the Gazette, and 2 national newspapers. And stakeholders felt strongly that's also limiting, so there should be other media as well. And also clause 13 is about the review, the withdrawal, and the amendment of protected agricultural areas. And the last one is clause 16. That's the listing of activities in agricultural areas. There's also a notice there only in the Gazette. So stakeholders feel that that should also be extended to other media. That's the first one, Chair.
Chair? Okay. Chair?
Honorable Masipa.
I was just wondering if Mayor Noxola can fly to where she's talking, the talking notes, where she's talking from, just to help us to just follow. Thanks, Chair.
Ma'am Kasia, are you speaking from notes or are you speaking from your own knowledge of the bill?
I'm speaking from the bill because I have a bill in front of me and I have made notes on the bill. However, the issue,
Proceed.
so with your indulgence, Chair, the issues that I'm raising have been sent to the members as well by Mayor Maledu yesterday.
Thank you.
Additional amendments. Thank you, Chair. The next one, Chair, I will skip because Tate Masipa has already spoken to it in respect of clause 15, that's 15.4F and 15.5. And then on clause 21A, Roman 21A Roman figure 1. ESCOM has made, Chair, I just want to indicate that some of these may be covered, but however, since there was no explanation on them, so I'm repeating them as proposed by stakeholders and also as accepted by the department in its responses. So clause 21A, Roman figure 1, ESCOM proposed an addition of the last part, read under the jurisdiction of more than one organ of state. And they propose that after organ of state to add or impact one or more organs of state. That proposal hasn't been reflected or spoken to in the A list. That's an assumption, and it was accepted by the department. Still on clause 20, 1A Roman figure 5. There was a proposal, any maps, okay, to include any information instead of any maps. So Roman figure 5 to read as any information and maps compiled in terms of section 16.4 are taken into account and end. That was accepted. And then, Chair, on clause 21 and 22, clause 21 is the establishment of committees, specifically the establishment of an advisory committee to advise the minister. And clause 22 is the appointment of technical and other advisors. So the comment there was that the substance of both provisions, that's 21 and 22, overlaps. And there was a recommendation that the two clauses can be consolidated into one. And I think this also stems from the fact that Clause 21.7 and 21.8 makes reference to advisory or technical committee. There were recommendations. Another recommendation on the same clauses was that the empowering provision in clause 21.1 be inserted after clause 21.6. 21.6 is the notice referred to in subsection 5 must stipulate the mandate of the technical committee within the context of the Act and the duration and composition of the technical committee. And the second insertion was clauses 21, 7, 8, and 9 be amended to also refer to technical and other advisors. I think that stems from the fact that the initial recommendation was that 21 and 22 can be consolidated into one clause. And it was further proposed that clauses 21 and 22 must further be amended to provide for MECs to establish similar advisory and technical committees and other advisors as required by the minister. These comments were noted, and the concession from the department was that clause 22 may be reconsidered. And there was no comment currently on these clauses, or how it has been reconsidered. The last one I'm going through the bill, Chair, is clause 31. Clause 31.3, because in terms of agricultural land, the department will be dealing with different stakeholders, including entities. There was a suggestion that reasonable notice may be required for the purposes of safety. This one came from ESCOM and might apply in other relevant entities to ascertain if the inspector can legally request access to some areas which might be restricted and to avoid infringement on other legislation. ESCOM made an example that environmental law requires that certain document must always be on site and cannot be removed. In this regard, it was proposed that 31.3 after subsection 6 to add may only as relevant legislation allows. The comment was noted and accepted. Clause 31.3 clause 31 subsection 3A. Members will recall that's the controversial one, where there was a lot of inputs from most of the organizations that made oral inputs to the committee. Clause 31 subsection 3A, an inspector contemplated in subsection 1, subject to subsection 6, may enter an agricultural land at any reasonable time without prior notice. I'm reading prior because it's already been referred to through the A list, for the purpose of ascertaining an issue required to ensure compliance with this Act. The comment was noticed and notice may be considered in respect of clause 31(3)(a). The last one on clause 31, subsection 5. This was from the Banking Association of South Africa. Clause 31(5) is about the seizure and removal of articles, substances, etc. by the inspector. The Banking Association was of the opinion that 31(5) must clarify that the state remains liable for any damage, destruction or loss of any article, substance, plant, machinery, book, record, or other document that is removed or seized from the agricultural land during an inspection. This was not responded to, Chair. So I'm not certain what is the view on that one from the legal team. And then if I go back, Chair, to clause 17, there were proposals that were made specifically by ESCOM for an addition of sub clause 17(a), Roman figure 3. They were proposing an additional Roman figure 3 that reads as to notify affected parties and organs of state to submit written comments on the proposed listing within a period of at least 45 days of such notice. The response from the department was that the bill does not have 17(a) Roman figure 3. Of course, the bill doesn't have, but ESCOM was proposing that be added. So a response in this regard might be required. This goes for clause 24. I think I will skip 24 because the legal team because the 24 ESCOM wanted timelines. But the context might be different because what they are proposing is that clause 20 deals with the clause 20 is the consideration of applications by the competent authority. I think they have, if I'm not mistaken, 30 days has been added there. So I'll skip that one that has been addressed. The last one from ESCOM is on clause 27, subsection 3. Okay, they are proposing a subsection 3, sorry, Chair. The proposed subsection 3 reads as the minister must issue a response to such an appeal within 30 days. I suppose this, as the legal team has indicated, the timelines, they have deferred them to regulations. That's all from my side, Chair. I don't know if my colleague, Dr. Manenje, has something else to add. Thank you, Chair.
Colleague Kamam Kashe, do you have anything to add, Dr. Manenje?
No, Chair. I am covered. Thank you.
Thank you to our content advisors. let me invite our parliamentary legal advisor as well as state law advisor to speak to those issues raised by the content advisors.
Thanks, Chair. I will leave some of the response to my colleague, the state law advisor, but our understanding of what has been read out were the concessions that were made by the department before the deliberations. For instance, the issue of prior notice was initially considered too, but after deliberations, the view was that if you give notice of inspection, it would defeat the entire purpose and might lead to concealing of some of the evidence that you would have gotten had you not given prior notice. So I am really not certain where we are now, but my understanding was that after the deliberations, those were the concessions that were made thereafter or during those deliberations were issues that we needed to consider for the A list. We'll leave the remainder of the response to my colleague, Mr. Van Breda.
Van Breda.
Thank you, Chair. Yes, Chair, I'm in agreement with my colleague, the Singisa. Chair, I am not a parliamentary law advisor. However, my experience and knowledge of the processing of a bill, Chair, we are now at the A list stage. So what the content advisor has referred to are in fact recommendations and proposed amendments made during the public hearing stage and deliberations. So when we draft the A list, Chair, we are guided by concessions made by the committee during the clause by clause process. So that is essentially what you would see in the A list. So there may be certain inputs made by members, but we look at what concessions were made by the majority of the committee, and that is what is reflected in the A list. Chair, if there are any concerns or queries in respect of certain clauses or certain amendments made on the A list, yes, I'll be glad to assist. Thank you, Chair.
Thank you, Van Breda. Honorable members, any questions of clarity or comments? Honorable Masipa.
Thank you, Chair. Sorry, Chair, I just want to greet the Minister, and I haven't seen that she was on the platform, but my apologies. Minister Dumela. Chair, the point I want to bring about, obviously, I'm not responding to the legal advisors now. There was obviously a point of that brought a lot of apprehension from the some of the submission that we received, and that is with regards to section, I think 31. Let me just see. Look, I'm having to look from the compliance inspection 31.3. Inspect any articles and so on and so on. So I think the whole thing is that the request obviously from the sector is that the entry onto the farm or the seizure must be done with a what you call a warrant. And when I looked at the plant health bill, has kindly defined that to say on section 8 we will be going through. It says power of entry, search, inspection, seizure with regards to land. A person authorized by the minister may perform under section, may on the authority of a warrant at any reasonable time enter upon or proceed over a land. I do not know if that was covered because you're going through the bill and you're going through the changes that were requested and so forth. But I just wanted to make sure that this is clearly noted that we would love to see that there must be at least a warrant of search and seizure, included. I know that prior notice, whether that include the warrant, I do not know, but I thought that is important to make that point, Chair. The other point, Chair, that I have got, let me just go up a little bit, is obviously a section we have obviously spoken about the land, the agriculture, the state land, and so forth. But the big question is that can the state be responsible and also be policeman for its own land? And I think that's where really the definition of the land become also kind of crucial. So I am just putting it to the state law advisors to really, not state law, but the parliamentary legal services to really advise as to how is the state going to be able to police itself as such. There's obviously some issues that were raised regarding the Section 26, G, Roman figure 2 and H. The question is, what is the real purpose of ownership profiling? Because we've got deeds registry that has got records of each and everyone who owns what, where, and so forth. Is this not really creating another, red tape, additional work, and so forth? Shouldn't we take this clause in particular out? We've got deeds registry, we've got the stats essay, we've got everything of the particular entities, the farmers as such. So those information are probably easy to pull from the deeds registry. So I don't see the need for this particular bill. There was obviously a section around equitability that talks to principle of equitability, which is obviously when one was looking at the previous bill that was proposed and the new bill, it wasn't covered in the old bill, but is covered now here. The question is, what is really the purpose of this equitability? Is it really necessary? Because here we're just looking at really the preservation of the land. How do we bring the principle of equitability? I think that's the question that maybe the legal guys can really help us around that one. My view is that we should delete this clause completely because it's irrelevant for this particular bill. Chair, those are my few submissions that I felt it's very important to make, and maybe the colleagues from parliamentary legal can advise or kind of give their input in that regard. Thanks.
Thank you, Honorable Masipa. Any other honorable member who may wish to give further comments or questions of clarity?
Chairperson.
Honorable Trader.
Good morning, Chair, and good morning to the colleagues, honorable members, our support staff and the department, also to the legal advisor or the legal team. Chairperson, I'm not really, excuse me if I may speak out of the points where we are, or I may not follow the process very well, but I want to speak on to clause 31, subsection 3A. Chair, on that clause, yes, it was a point of discussion, and if my memory serves me well, which it normally does, the majority of members deliberated on this, raised the issues that what will be the point of inspection then if we will give notice? the experience that we have is that immediately the stakeholders, or the farmers, know that the department is coming or there will be inspection, they will put systems in place and everything will look normal. Then you won't get to the gist of what is happening in the entity itself. To such that we said there is no need. There must not be a notice that this is happening. But the inspectors must inform the relevant other departments that they would carry their inspection with, to avoid all the concerns that were raised. For instance, if I remember, Chair, there was a proposal or a comment that seeks to say our inspectors have their mandate and are qualified to do or to carry their work. They must also inform SEPs should there be a need or any harm that they are posed with. They know what to do. Chair, on other bills that were proposed, on the proposals of ESCOM, which is on clause 17, subsection A, which one do I want to speak to, Chair? I'll make note of this. On clause on clause 27, subsection 3. Chair, can I pass this one? I seemingly I cannot even read my writing now.
Thank you, Honorable Chwete. Any other honorable member who may wish to raise a question of clarity or a comment before we hand back to the legal advisors? Thank you, honorable members. Mamu Zenani, the parliamentary legal advisor, for responses, and Baufan Breda.
Thanks, Chair. In respect of clause number 31, subclause 3, 3G, I think it's 3A and G. I think Ms. Chwete has covered us that indeed it was deliberated on, and the consensus was that the clauses be left as they are. The inspectors are qualified people that know what to do when they get to the premises, and that there would really be no point in going, if they had gone for an inspection, there would be no point in them going back to apply for a warrant if they have found something that is not supposed to be there, for them to go back and apply for a warrant for them to be able to seize whatever it is that needed to be seized at that time. It would defeat the purpose. So against that background, there was no amendment that was made. And in respect of, I think it's clause 26G, we did not understand the deliberations and consensus to be that it should not be there altogether. So on that against that background, we did not think of deleting it altogether. The last question would be, can I just perhaps check if my colleague from the sectoral advisor has any additions as well?
Yes, Chair, may I provide input?
Go ahead, Baufan Breda.
Thank you, Chair. Chair, with regards to clause 31, as my colleague has indicated, that what's reflected in the ALIS is what was agreed to, or was the consensus reached by the committee. However, Chair, where there are constitutional issues or concerns, we do consider that, and then obviously provide the committee with the relevant legal advice, Chair. With regards to search and seizure contemplated in clause 31, Chair, that clause is in fact in line, in accordance with the Constitution, as well as the relevant Constitutional Court judgments. Those judgments include Mystery versus the Interim National Medical and Dental Council of South Africa, Gardner versus the Minister of Finance and the SARS Commission, as well as Estate Agency Affairs Board versus Auction Alliance, Chair. Now, warrantless search and seizures are in fact permissible in certain instances, and a requirement of a prior warrant would be likely to frustrate the state's objectives behind the search and seizure. And this is exactly what the Constitutional Court has held in those judgments and other judgments as well. Chair, the Constitutional Court has also held that when legislation authorizes warrantless inspections, provision must be made for a constitutionally adequate substitute to ensure certainty in the conduct of the inspections. And now the court further held that the legislation must also provide for a manner of conducting searches and that accords with common decency and is not more intrusive than is necessary. But what the Constitutional Court has been consistent in, Chair, is expressing the view that when it comes to a private dwelling, a warrant is definitely required. Now, if you look at clause 31, subclause 1 of the bill, let's have a look here, Chair. So it's subclause 3. Now, which provides that an inspector contemplated in subsection 1, subject to subsection 6, may, and then it provides all the details and guidance as to how an inspection should be conducted. Now, if we look at subsection 6, subclause 6 rather, it provides that an inspection of a private dwelling may only be carried out by an inspector when authorized in terms of a warrant issued by a judge of the High Court or a magistrate who has jurisdiction over the agricultural land on which the private dwelling is situated. So, and furthermore, in accordance with, in alignment with the Constitutional Court judgments, if you look at subclause 8, subclause 8 of clause 31, it provides that an inspector who enters and searches any agricultural land or private dwelling under this section must conduct such search or seizure with strict regard for decency and order, and with regard for each person's right to dignity, freedom, security, and privacy. So, Chair, the constitutional right to privacy has been considered, as well as the applicable Constitutional Court judgments in developing or drafting this clause. So I am happy that the clause is indeed constitutional. Chair, there were a few questions regarding whether the state can police its own land and whether clause 26 is absolutely necessary, and what is the purpose of equitability. So I think that as legal advisors, we are not. It's not appropriate for us to answer those questions. The department. It's more appropriate for the department to respond to those policy issues. Yes, thank you, Chair. That's all from me.
Thank you, Bafan Breda. Honorable members, are there any follow-up questions before we wrap this up? Honorable Masipa.
Chair, thank you very much, and thanks to the State Law Advisor. Chair, I just want to say that from our side, we really do not agree, especially with regards to this clause 31, if I'm correct, is it F or G, with regards to, sorry, let me just get my notes together because I'm working on two screens. Where it says that you can lend cession without any prior notice. So we are not comfortable. We object to that. And Chair, what is very important that we also need to note is that even the labor, when they do their inspection, they provide prior notice. The other issue that I must just also bring to attention, Chair, is that let's just be careful of bringing something, bill that is not going to really be implementable in various aspects. So those are just my little bit of concerns. In as far as the state law says that, the issue of the state who's going to police the state, is not in his purview to really comment. But I think these are some of the issues that might not be implementable, because we might have a law, but a law that cannot really be carried out in terms of really on the state land specifically, because this for me is a serious concern. And I think the issue of the deeds registry, which obviously cover all the records, of everybody, that owns a property, that should suffice. This bill should not really be covering. This bill should be covering the preservation of the land as such. And so Chair, I thought I just needed to make those particular points with regards to our submission around the bill. Thanks.
Thank you, Honorable Masipa. Honorable members, any other honorable member who may have a follow-up question or comment? Silence means consensus, honorable members. Honorable Masipa, in regards to issues that you may be raising and objecting to, we may agree to disagree, and it is in that spirit that we have gone through each of the clauses, and honorable members have had the opportunity to raise the issues of concern, and legal advisors have responded adequately. I will offer them the opportunity to respond to your follow-up, but it was mostly a comment on your part. If not anything, we'll move on with the program of the day. Mamo Zenani, any other additions that you may wish to respond to in terms of the follow-up comments from Honorable Masipa?
Thanks, Chair. I think most of the follow-up points have already been covered. I have I understand them to be comments and have no response.
Thank you, Mamo Zenani. Baufan Breda, State Law Advisor, any further responses on the follow-up?
Nothing further from me, Chair. Thank you.
Thank you, honorable members. That is our legal advisors from the Parliamentary Legal Services, as well as Uba van Breda from the State Law Advisor, who have assisted in taking us through the A list. And we have come to the end of our program or agenda for the day. As I had said earlier when we started this session, we will request now from the legal advisors, both parliamentary legal advisor and the state law advisor, to therefore develop the final A list and the B version for consideration, which will be dealt with in our next meeting, that being on next week, Tuesday, honorable members. Manyamza, Mamkakaza, any other matters on our agenda for today? Manyamza, Mamkakaza, Nisenati.
Mr. Nani, I'm waiting for Mama Nyamza to respond.
You can go first.
What was the question, Chair?
I said Manyamza and Mamukakaza. Are there any other matters for consideration for today by the Portfolio Committee on Agriculture, Land Reform and Rural Development? As we've come to the end of our agenda, we will now await
Nothing, Chair.
from the legal
Except
advisors to develop the final A list and the B version for consideration in our next sitting, which will be next week. So there's nothing else on.
There's nothing, Chair, but Friday we are having a meeting.
On this coming Friday, we'll have a meeting.
Yes, on deeds
what?
registries. On deeds registries.
On our deeds registries.
Please, amendment bill, yes, Chair.
Thank you, honorable members. With that said, then we will meet again in our next sitting, which will be on Friday, where we'll be engaging with the presentation from the deeds registration. Allow me, therefore, to thank you, honorable members, for having taken time on this wonderful Tuesday morning to be able to join the Portfolio Committee on Agriculture, Land Reform and Rural Development on this A-list reading by our legal advisors from Parliament Legal Services as well as State Law Advisor. On behalf of the committee, we would like to thank both Parliamentary Legal Services and the State Law Advisor for having assisted us to go through the reading of this aid list and in considering the amendments that were effected. Mamu Zenani as well as Ubao and Preda. Committee will forever be indebted for you for your assistance. Allow me to thank the Honorable Minister Mamutoko Didiza having joined us on this virtual meeting all the way from Qatar in the Middle East. We thank the Deputy Minister Bausquacha and the officials of the department who took time to be with us. Honorable members, allow me to thank our staff, the Secretariat, the content advisors, the researchers, and everyone that enables us to be able to get through these sessions and be able to have our sittings. Let me remind honorable members that we do have plenary at 2:00. So for those that will be making their way into the Good Hope chamber, Have safe travels and see you in the house. And those that will be joining virtually, please join timelessly so that we can get the session off on a good quorum. That brings us to the end of our meeting, and the meeting stands adjourned. Have a great week ahead, honorable members. Thank you. Bye.
Thank you, Chair. Bye-bye. Thank you, Chair.
Thank you, Chair.
Thank you, Chair.
Chairperson.
Thank you, Chair. And I didn't do miss. Cup. Dumela.
Dumela mre.
O kae na?
Ke teng ra o kae?
Ha o sa ntumedisa wena ke ntse man.
Ha
o sa ntumedisa wena ke ntse.
wena mathata ga go wena nna ke ya itse we are doing very well as opposition. Yana wa tsa wena o ruling party. You are doing well as opposition. Sorry bona mome.
Wena wa ntsokoza wena. Wena wa ntsokoza. And that is Squatch. Deal with this man. Hey.
Listening.